Today, I would like to discuss probate. Probate is a term that many people have heard but may not know exactly what it means. The word probate is a general term that describes the court process used to settle a person's estate after he or she dies. In Wisconsin, an estate is required to go through probate if the total value of property in the estate is more than $50,000. When determining if a person's estate is more than $50,000, the value of any life insurance, retirement plans, or other accounts that pass directly to a named beneficiary are not counted. If an estate is less than $50,000, the estate can be settled using a small estate affidavit rather than having to go through probate. Some people believe that if they sign a will, their estate will not have to go through probate. However, wills are actually designed to be used in conjunction with the probate process. Even if a person has a will, if his or her estate is over $50,000, it will need to go through probate. Probates generally involve gathering the deceased person's assets, paying his or her outstanding debts and expenses, and distributing any remaining assets to the beneficiaries named in the person's will. If a person dies without a will, state statutes determine who inherits the assets. Most estates are settled through an informal process, which does not require actual court hearings. However, some estates do require a formal process, which generally requires a minimum of 2 court appearances. The person in charge of managing the probate is the personal representative. The personal representative is usually nominated in a person's will. A will can also be used to nominate a guardian if a person has minor children. Even though probate is not as terrible as people often hear, it is still something many people want to avoid. Fortunately, there are a variety of ways to prevent your estate from going through probate. Beneficiary designations on life insurance policies, retirement plans, and other financial accounts allow those assets to be paid directly to the named beneficiary rather than go through probate. Jointly titled assets held by spouses and joint tenants similarly avoid probate. Another common method to avoid probate is to use a revocable trust. A revocable trust is established during a person's lifetime and may be amended or revoked at any time as long as that person is competent. Spouses can establish a joint revocable trust. Property that is titled in the name of the trust or are paid to the trust upon a person's death will avoid going through probate.
For more information, call or visit us online. Anderson O'Brien, exceptional attorneys in your community.